I've heard it from members of this planning board as well as members of the council. Despite what Treelo White, the town attorney's legal opinion has been on the record, that it is not, certain individuals still keep insisting that it is. For some strange reason, this issue continues to come up and circulate, even though it has been put to rest on several occasions by your own town staff and town attorney. Many folks have expressed concern that approving this application will open the door to allow developers to buy up some of the older buildings in town and build similar type hotels as we are proposing. This is absolutely not true. To believe this would mean that it would be currently possible to build a hotel such as the one we have today on one of those other properties in town. This is simply not possible to do. Are you all clear that this will not set a precedent? The approval of the application?
Peter, I understand that it won't set a precedent, but do you? I mean, why is it that you feel confident that this isn't going to set a precedent? I have my own reasons, because I can read, and I've been listening to this stuff for 4 years.
Michael, I think we can deal with this when we come to discussion. The idea is that Mr. Paloka puts forward his presentation. It will then be up to the public and public comments to comment on this, and then we will deal with what has been said in the presentation and, if necessary, what's been said in the comments.
Fair enough.
Proceed.
I find comfort in the legal opinion of my attorneys as well as the town attorney that this, the approval of the proposed text changes cannot and would not set a precedent. Perhaps Mr. Biggs can confirm this information for you to ensure that your recommendation is based on factual information and not my opinions.
Is that a question of me? Would you like me to confirm that? Or do you want to just proceed and then you can ask me later?
No, you can confirm it if you wish to.
We did make that statement, that this would not set a precedent.
Right.
Another issue is that of spot zoning. Some folks have expressed concern that approving this application would in some way be considered illegal spot zoning. Our application does not request the rezoning of our property at all, so it cannot be considered spot zoning. Are all the planning board members clear on that? If not, please express yourselves now. Perhaps Mr. Biggs can confirm this information for you to ensure that your recommendation is based on factual information and not my opinions. So if you'd like to know whether this application is in any way spot zoning, your town attorney is ready to answer that question.
Are you, Mr. Biggs?
Certainly. Yeah, it's not a zoning application, it's a comprehensive plan
Right.
text.
Right.
Absolutely.
Yeah, we understand.
I think we
you know.
established that,
Thank you.
2 years ago. You're at,
Yeah. Go over, yeah.
Member Robinson, you do understand that we've addressed this over and over and over again for the last 4 years. But despite doing that, it still comes up. So it's important for us in this forum to put it to rest, so that it's not something that keeps coming up and stops progress. Some folks have said that what is being proposed is a timeshare. The fact is that the proposed text amendments strictly prohibit timesharing. So it cannot and will not be a timeshare. Again, you're welcome to ask your town attorney to confirm that.
We hear you.
Traffic. Some folks have expressed concerns that there will be unbearable traffic if this application is approved. The fact is that the town received a letter from the Palm Beach County Traffic Division which stated the proposed redevelopment project meets the traffic performance and concurrency standards of Palm Beach County. Have you seen that letter?
I think, Peter, that that is not relevant
Yes, it is.
to what we are discussing tonight. What we're discussing tonight is proposed amendments to the comprehensive plan. When a site plan is presented for an actual construction, that is the time to examine such things as traffic control, traffic congestion, traffic movements. I don't think it is relevant to what we are discussing tonight, which is amendments or proposed amendments to the comprehensive plan.
I think it's important to address any open issues that still exist regarding this application.
Answer the
I,
misinformation
Mr. Chairman,
that is spread.
I respectfully disagree, even though I believe that we can speed things along in terms of the applicant's style here this evening, but when it comes to whether it's the traffic thing, he's looking for confirmation as I see it, because without confirmation and agreement of facts, it can be disagreed with as presented, but if they are acknowledged as factual, or that he's laid it out, that's what the discussion and that's what the vote is going to be based on. It's not going to wait till, I mean, they do it on the town council, which is nuts. They take a vote, then they ask the public what do they think. You know, we're not there yet, thank God, so I hate to see us go there.
The purpose of these hearings, I believe, is to fact find and for us to have dialogue and for us to answer anything that's not clear in anyone's mind.
We will ask questions if there's anything we're not clear on.
I would hope so, but the public also would like to hear answers to questions that they have, and these are some of those questions that seem to come up over and over again.
They will hear them in the proceedings that follow the public comment.
Some folks have said that the DCA is against our proposed text amendments. In 2009, together with the help and collaboration of the town attorneys, we prepared the various comprehensive text amendments that were later approved and transmitted to the Department of Community Affairs for its review. After a thorough review of our proposed text amendments, the DCA then issued its ORC report. Again, together with the help and collaboration of the town attorneys, we worked to address each and every one of the DCA's objections, recommendations, and comments in their report. Ultimately, we received written communication that our response to the DCA's ORC was found to be in compliance with their standards. Of course, this was not a final determination because our application was required to be adopted prior to a final determination by the DCA. The important thing here is to realize and understand that there weren't any unresolved issues with the DCA's ORC. Everything was addressed to their satisfaction.
I would make one comment on that. The DCA asked for clarification for the formula that 2.8 hotel units would correspond to one condo or co-op unit. That was not resolved because in the final revision put to the council in October, no reference was made to that. It was still 99 units, and it was still not explained how that came about in relation to the allowed density of 33 units per acre. However, we can deal with those things when we come to the discussion.
Actually, Chairman Navarre, that item was addressed by us with the help of your town attorneys, and we did change the verbiage on the intensity to read as follows. A maximum of 99 hotel units will be allowed on the property depicted on the existing land use map, where the existing 58-unit motel is currently located. That verbiage was satisfactory to the DCA. And again, don't take my word for it, you can ask your own town attorney.
I'm not sure it was acceptable to the DCA because the application never went forward the second time to the DCA.
If I might, so we don't get dragged down into this. There was a piece of case law that came out recently. It came out in 2008, and it basically said that transient hotel rooms, transient, not residences, but transient hotel rooms were not considered residences in your normal density of whatever you've set forth in your comp plan. So that was the issue in the case law, and the case came down on the side of, if you say that they are under Chapter 509 and the transient lodging hotel units, then that doesn't necessarily have to abide by your density regulations. And therefore, DCA as an intensity, since it is a commercial use at that point, the intensity was okay with them.
Right.
So we got the verbal on that, and they said they wouldn't challenge that later if it was sent up.
Thank you.
Is there any planning board member that thinks that there were any issues regarding that fork that were not resolved? Some folks have said that if you approve this application, it will change the permitted density in our town code. We are proposing a maximum of 99 hotel units for the hotel property, if redeveloped. This would apply to the existing hotel property only. We are not proposing to change the current permitted density ratio in the town's code as it relates to residential buildings. That will remain unchanged. By approving this application, you will not be changing the density standards for the rest of the town. Is everyone clear how this application affects, or I should say doesn't affect, the town's density standards? If anyone believes that it does in an adverse way, please let us know so we can address it.